Misrepresentation can be defined, according to Ewan McKendrick, as an ambiguous false statement made by one party at or before the time that the contract is made, pertaining to matters of material fact or law. However, the Malaysian definition, as defined in Section 18 of the Contracts Act 1950, does not require that, to be a misrepresentation, the pre-contractual statement must have materially induced the contract. The definition of misrepresentation in Section 18 is inclusive or open-ended. It is not exclusive. Hence, the circumstances set out under each of its 3 paragraphs are not the only instances of misrepresentation. A contract induced by misrepresentation is voidable at the option of the innocent party. Section 19, subsection 1 of the Contracts Act 1950 also states that when consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. Let us break down what the definition means. Firstly, what is meant by a false statement of fact or law? Misrepresentation must be an unambiguous false statement of existing fact. The need for a statement underlines the point that a failure to disclose information will not generally constitute a representation, but the courts are flexible with the interpretation of statement, where it can also be made by conduct as well as by words. A case law to illustrate this would be Smith and Land and House Property Corporation. The plaintiff put up his hotel for sale, stating it was let to a most desirable tenant. The defendants agreed to buy the hotel. The tenant was bankrupt. As a result, the defendants refused to complete the contract and were sued by the plaintiff for specific performance. The Court of Appeal held that the plaintiff's statement was not mere opinion, but was one of fact. Secondly, what is meant by material and which induces the contract? The precise meaning of materiality was not always clear, but it seems to have meant that the misrepresentation must have been such as would affect the judgment of a reasonable man in deciding whether or not to enter into the contract on these terms. If the misrepresentation would have induced a reasonable person to enter into the contract, then the court will presume that it did induce the representee to enter into the contract, and the onus of proof is then placed on the representer to show that the representee did not in fact rely on the representation. This was held in the case of Muse Prime Properties and Adhill Properties. In practice, it is extremely unlikely that a representee would be able to prove that he was induced into the contract by an immaterial misrepresentation. There are 3 situations the claimant will be unable to show that representation induced the contract. The first, the claimant was unaware of the existence of the representation. The second, the claimant knew the representation was untrue. And the third, the claimant did not allow representation to affect his judgment. This can be illustrated in the case of Atwood and Small, whereby it was held that he was unable to rescind the contract because he had relied upon his agent's report rather than upon Atwood's representation. From this, the elements of misrepresentation can be established. They are that the representation must be an unambiguous false statement of fact, the representation materially induces the contract, it must not be a mere opinion, mere puff, statement of intention, failure to disclose information, it may be oral, written, or inferred from conduct. However, silence does not necessarily amount to misrepresentation. The elements were also established in the Malaysian case of Sim Tong Realty and Teh Kim Dar, where the Court of Appeal added one more element, which is that representation must be addressed to the party misled. Now, the following 3 categories are just a few among many of statements that have been held not to constitute statements of existing fact and therefore cannot amount to actionable misrepresentation. Number 1, mere puff. A commendatory statement may be so vague as to be neither a promise which is incorporated to the contract as a term, nor a statement of fact. A case law to illustrate this would be Carlisle and Carbolic Smokeball Company. The more specific the statement, the less likely it is to be treated as a mere puff. The second, opinion or belief. A case to illustrate this would be Bissett and Wilkinson, whereby a vendor of a farm in New Zealand, which had not been used for sheep farming before, represented to a prospective purchaser that, in his judgment, the land could carry 2,000 sheep. In fact, it could not carry 2,000 sheep, and the purchaser, when he discovered this, sought to set aside the contract on the grounds of the vendor's misrepresentation. He was unable to do so because the vendor's statement was not a false statement of fact, but a statement of opinion which he honestly held. And the third, statement of intention. A case law to illustrate this would be Wales and Wadham. A person who fails to carry out his stated intention does not thereby make a misrepresentation. If you state your intention but fail to carry it out, it means there is no misrepresentation. But if you lie by your intentions, misrepresentation is present. Note, it must be shown that the representation was addressed to the party misled. There are 2 ways where this can be shown. The first, direct communication of the misrepresentation to the claimant by the representer. The second, addressed by the representer to a third party with the intention that is passed on to the claimant.
There is a duty not to misrepresent, but there is no general duty in the English and Malaysian contract law to disclose at or before the time of making a contract. Through the passage of Bell and Lever Brothers, the House of Lords mentioned that an exception to the rule would be contracts of good faith, where the material facts must be disclosed. Also, in Section 17 of the Contracts Act 1950, the general rule can be overturned and constitute a fraud when active steps are taken to either hiding the facts from the other party or to not let the other party know of the material facts. Section 17 explains the circumstances where the rule doesn't apply when it is the duty of the person keeping silent to speak, or unless his silence in itself is equivalent to speech, which translates through the illustrations of Section 19 for Section 17 of the Contracts Act, where in first instance, where the seller has a knowledge of the horse that is unsound, but has no duty to tell the buyer of the condition of the horse. But if the buyer was his daughter, it is the seller's duty to let her know whether the condition of the horse is sound because of their relationship. Second instance, when a buyer and a seller enter a contract and the seller has information that would make the buyer stop the contract, the seller has no bounds to tell. On the other hand, if the buyer tells that if you don't say anything, I'll assume that my goods are in good condition. Now in this stance, the seller has a duty to speak up, or his silence will amount to the agreeableness to the terms of the contract.
What are the types of misrepresentation? The first type of misrepresentation is fraudulent misrepresentation. Fraudulent misrepresentation, in addition to being a ground in which a contract may be set aside, constitutes the tort of deceit. The meaning of fraud in law has been defined in the case of Derry and Peake, whereby Lord Herschel proposed 3 propositions. Firstly, there must be a proof of fraud, and nothing short of that is sufficient. Secondly, fraud is proved when it is shown that a false representation has been made, knowingly, without belief in truth, recklessly, careless whether it be true or false. If fraud is proven, the motive of the person guilty of it is immaterial. Deceit is a difficult matter to prove, and it should not be alleged unless there are good grounds to believe that fraud has indeed been practiced. Thus, fraud is not likely invoked in courts. A statement may be fraudulent although it was made without bad motive or bad intention. This can be seen in the case of Polhill and Walter. An agent purported to accept a bill of exchange on behalf of his principal, knowing that he had no authority to do so, but believing that his principal would ratify. He was held liable in deceit. Once it has been proved that the plaintiff has acted upon a false representation, which the defendant did not believe to be true, liability ensues, although the defendant may not have been actuated by any bad motive. Now we'll take a look at fraud under Malaysian law. Section 17 of the Contracts Act lays down 5 acts which may constitute fraud. Section 17A, subsection A, B, and C of the Contract Act would cover the common law of fraudulent misrepresentation as defined by the House of Lords in Derry and Peake in the judgment of Lord Herschel. However, fraud as defined in Section 17 is wider than common law by the virtue of Section 17 subsection D stating any other act fitted to deceive, and Section 17 subsection E stating any such act or omission as the law specially declares to be fraudulent. Unlike common law, the act must be made with the intent to deceive another party or to induce him to enter into a contract. The application of Section 17 subsection D has been illustrated in the case of Keng Tri Lian and Wong Tak Tong, whereby the federal court held that there was fraud as the respondent had been misled into signing a second agreement. This falls within the meaning of Section 17, subsection A and D of the Contracts Act. Section 17D has also been applied in Jong Chuk and Chong Tung Sang and 5 others. Section 17E, on the other hand, applies where the law specifically declares an act or omission to be fraudulent. It also applies where the disclosure of certain kinds of act is expressly required by law. In Datin Zainun binti Ismail and Tuan Mina binti Syed Abdul Rahman and another, Justice Muhammad Zahir stated that the burden of proving the charge of fraud lies upon the person who seeks to impeach the validity of any transaction on such a ground. The onus is on the plaintiff who advances the claim of fraud. The standard has been set at between the lowest requirement of proof on a balance of probabilities to the higher requirement of proof beyond reasonable doubt. This has been affected by the question whether it is proof of fraud in civil or criminal proceedings. In Liu Sin and Chong Mu Kun, the federal court agreed with the test set out by Lord Denning in Bader and Bader, which stated that the degree depends on the subject matter. A civil court, when considering a charge of fraud, will naturally require a higher degree of probability. The next question is, can silence amount to fraud? The explanation to Section 17 depicts that as a general rule, fraud is not committed by keeping silent. This is similar to common law. However, there are two exceptions. Firstly, there exists a duty for the person keeping silent to speak, and the silence is equivalent to speech. Similar to common law, an agreement that has been consented under fraud is voidable at the option of the innocent party under Section 19, subsection 1 of the Contracts Act.
The next type of misrepresentation is negligent misrepresentation. It requires the statement maker to believe that the falsity is true, but has no grounds to believe so, or hasn't taken the necessary and reasonable measures to verify the information. The essential elements are the defendant imprudently making a false statement to the claimant, there are reasonable grounds to believe that the statement is reliable, the statement is in fact relied upon, and there's a special relationship between the parties. Before 1964, the courts classified all misrepresentations that were not fraudulent as innocent. However, after the landmark case of Hedley, Byrne and Heller in 1964, the judicial perception of false statements shifted to allow for the inclusion of negligence. In the former case, the claimants alleged that the defendant bank gave a negligent credit reference, which the claimant relied upon, and as a result of the defendant's inaccuracy in stating that a third party could meet its monetary obligations, the claimant suffered financial loss. Thus, an action was brought forward to advance that the defendant bank was liable in damages. This case is monumental because the court established that negligent misrepresentation may give rise to an action for damages for financial loss caused thereby. This is applicable even if there is no contractual or fiduciary relationship between the parties, because the court will imply a duty of care if there is some other special relationship between them. In White and Jones, 1995, Lord Mustill extracted the four themes that emerged out of Hedley, Byrne and Heller, namely mutuality, special relationship, reliance, and undertaking of responsibility. According to Nicholas Hoggard, in cases of negligent misstatement, the claimant, rather than being the misfortune coder to the chain of causation, became a necessary link in that chain. Self-evidently, the misstatement found its potency only in reliance. As a result of this, under Section 2, subsection 1 of the Misrepresentation Act 1967, the defendant has the burden of proving that they had reasonable ground to believe and did believe in the truth of the representation up to the time of making of the contract. Otherwise, that person shall be so liable, notwithstanding that the misrepresentation was not made fraudulently. In Malaysia, Section 18 of the Contracts Act 1950 states that misrepresentation includes any breach of duty which, without intent to deceive, gives advantage to the other person. The other constituent elements consist of the existence of some duty owed by one party to another, a breach of that duty, an advantage to the party in breach, and the statement misleading the other party to his prejudice. This is a statutory recognition of the element of negligence, which was explicitly mentioned by Justice Gopal Sriram in Abdul Raza bin Datu Abu Sama and Shah Alam Properties 1999. As he stated, misrepresentations are of three types, depending on the state of mind of the maker: fraudulent, negligent, or innocent. In the recent case of Dr. Brahma Sendirian Berhad and another, and Bank Kerjasama Rakyat Malaysia 2017, Judicial Commissioner Wong Kian Kiong outlined the Malaysian position as follows. There is no distinction between liability for negligent misstatement and liability for negligent acts or omissions. And in deciding whether party X owes a duty of care to another party Y, the court shall consider the following: whether there is sufficient legal proximity between X and Y.
Moving on to the last type of misrepresentation, which is innocent misrepresentation, where they are neither fraudulent or negligent. An innocent misrepresentation exists where the statement maker can demonstrate reasonable grounds of belief in the truth of the statement, but the statement is still false. An example of this would be in the case of Lauhitia and Hardiel Engineering, where the plaintiff tried to rescind the contract from the defendant's non-disclosure of facts to the plaintiff. The court held that the buyer must ask the questions or the seller will not be liable for not disclosing information unless the parties are of utmost good faith or in a fiduciary relationship. To establish innocent misrepresentation, the factors are: the statement is false, the state of mind of the maker of the statement is true, there are reasonable grounds. An example of innocent misrepresentation can be shown in the case of Rutledge and McKay, where the plaintiff sued for breach of contract for the misrepresentation of the model of a car, but in the terms of agreement, there was no mention of the model of the car, and during negotiations, which means that it was an innocent misrepresentation and there were no damages. This can be mirrored in the definition of innocent misrepresentation for Malaysian law, where in the case of Lee Chong Fa and So Man Yok, Justice Abdul Malik Ishak stated, an innocent misrepresentation is said to occur where the representation is false, but made by the representor with reasonable grounds for believing it to be true at the time when it was made and at the time when it was entered to. Through the cases of Lokon Fat and Portland Golf Resort, and Gemakota Enterprise Syndrome Berhad and Public Bank Berhad, interprets all the subsections of Section 18 of the Contracts Act 1950 to innocent misrepresentation. In the case of Lokon Fat and Port Klang Golf Resort, where in this case, due to the statement of a golf resort brochure that promised a huge variety of facilities, but it was not provided, the High Court deems the act to be an innocent misrepresentation, as the statements were to gain more members of the golf course. It falls under Sections 18, subsection A and C of the Contracts Act. In Gemakota Enterprise Syndrome Berhad and Public Bank Berhad, the plaintiff wanted to rescind the contract for the misrepresentation of the proclamation of sale of the defendant's property. The court held that it was wrong due to Justice Kamlanathan Ratnam saying, I cannot but hold that there has been an innocent misrepresentation of facts falling within Section 18, subsection B of the Contracts Act. As soon as the misrepresentation had been discovered, the defendant stated that the true description to the second proclamation of the sale.
Now that we've covered the three types of misrepresentation, what happens then? Of course, there are avenues in the legal systems that are there to help the victims. There are several remedies that are available to the innocent party. These remedies include, firstly, rescission of the contract, setting up the misrepresentation as a defense. Secondly, indemnity pursuant to rescission. And thirdly, rescission plus damages. So rescission, what is it? A contract which is rescinded for misrepresentation is set aside for all purposes, both prospectively and retrospectively, with the aim of restoring the parties as far as possible to the position they were in before they entered the contract. It is available for all types of misrepresentation. However, it is not automatic, and a party that wishes to rescind must take active steps to do so. Example, bringing the decision to the eyes of the other party, or sometimes obtaining a court order. The right to rescind may be lost as well under several circumstances. These circumstances are known as bars to rescission. Firstly, if the claimant affirms the contract after finding out that a misrepresentation has been made to him. Secondly, if a bona fide third-party purchaser for value acquires the goods which constitute the subject matter of the contract before it is rescinded. Thirdly, lapse of time. And fourthly, where it's impossible to return the parties to their original position, the courts aim to avoid the unjust enrichment of the claimant as a result of rescission. Indemnity refers to payment of money designed to put a person back to his former position upon the rescission of a contract. It is in the nature of a restitutionary remedy that, for example, the innocent party may recover his actual out-of-pocket expenses incurred in performing until rescission obligations arising out of the contract. This remedy is available to the innocent party in addition to rescission, but only expenses directly related to the obligations of the contract are recoverable. We can see this in the example of the case Whittington and Sealhane, where he was only entitled to an indemnity as to what he had spent under the actual terms of the lease. Now, let's look at the damages in a more in-depth view as we talk about each misrepresentation individually. So firstly, we have fraudulent misrepresentation. What is the basis for assessment of damages under fraudulent misrepresentation? The general principle is, under contract law, the claimant recovers damages that will put the claimant into the position that he would have been in if the contract had been performed, as if the representation was true. We could see this happening in the case of Smith Newcourt Securities and Scrooger Vickers Limited, where it was held that the primary rule is that the victim of fraud is entitled to compensation for all the actual loss, including consequential loss, directly flowing from the transaction induced by deceit. Secondly, we have negligent misrepresentation. What are the damages under it? It is the same as the measure for negligence generally, which is all damage that is caused by negligent act or omission, which is reasonably foreseeable. This can be contrasted with fraudulent misrepresentation, where all direct losses that are not too remote, foreseeability by the defendant is irrelevant. A famous case under negligent misrepresentation that we can look at is the case of Hedley Byrne and Heller. So, negligent misrepresentation may give rise to an action for damages for financial loss caused thereby. This is so even if there's no contractual or fiduciary relationship between the parties, because the law will imply duty of care if there is some other special relationship between the parties. So under the case, the liability for negligent misrepresentation arises when 1. The defendant carelessly makes a false statement to the claimant. 2. Circumstances are such that it is reasonable to assume that the statement will be relied on. And thirdly, the statement is relied upon. And fourthly, there is a special relationship between the parties that gives rise to the duty of care. Lastly, we have innocent misrepresentation. It is important to remember that prior to the Misrepresentation Act of 1967, rescission was the only remedy for non-fraudulent misrepresentation, and there was no right for damages. There is still no right to damages for innocent misrepresentation, but in Section 2, subsection 2 of the Act, it gives the court a discretion to award damages instead of rescission in cases of non-fraudulent, subject to some requirements being fulfilled. Another case that we can look at under innocent misrepresentation can be the case of Oscar Chess Limited and Williams. So in this case, the seller of a car misstates the year of make of a car to his buyer, and then the buyer sues the seller for damages for breach of contract. His contention was that the statement regarding the year of make of car was a warranty, although it was held that the statement itself was not a warranty but an innocent misrepresentation inducing entry into the contract. The buyer's remedy was therefore rescission of the contract itself, not damages for breach of contract.
We look to the Contracts Act once more to understand the effects of misrepresentation under Malaysian law. According to Section 19, subsection 1, when consent is obtained through fraud or misrepresentation, the contract so formed is voidable at the option of the party whose consent was so caused. Similar to English law, a contract born of misrepresentation is not void ab initio. Rather, it is deemed valid unless the misled party takes positive action to rescind it. Alternatively, Section 19, subsection 2 provides that a misled party may also affirm the contract and insist that he shall be put in the position in which he would have been if the representations made had been true. In short, Section 19 sets out the two avenues of relief available in Malaysian courts: rescission or affirmation. Rescission under Malaysian law has the same effect as English law. It sets aside a contract both prospectively and retrospectively. As stated in Section 66 of the Contracts Act, when a contract is rescinded, any party who has received any advantage must restore it or compensate for it to the party from whom they received it. In the case of Badiadin bin Muhammad Mahidin and another, and Arab Malaysian Finance Berhad, the court had to consider the issue of the sale of Malay reservation land as security for a breached loan agreement. The judge declared that the appellants had received an advantage from the respondent bank. Thus, they were ordered to sell the land and to use that money to pay the debt owed to the respondent. It bears mentioning that the principle of the loss of right to rescind is a part of Malaysian law as well, with the same bars as English law: affirmation, acquisition of rights by a bona fide third-party purchaser, lashes, and where restitutio in integrum is not possible. When a contract is rescinded, the misled party will be entitled to the return of any advantage given to the guilty party as stated under Section 66. However, depending on whether the misleading information was a fraud or misrepresentation, the party may also make an additional claim. Let us look at this one by one, starting with fraud. The Court of Appeal in Abdul Razak bin Dato' Abu Samah and Shah Alam Properties held that in the case of fraud, the misled party is entitled to an award for damages in addition to rescission. In assessing damages for cases of this nature, the objective is to place the innocent party in the position they would have been in had they not relied on the fraudulent statement. Thus, the innocent party is entitled to recover all expenditure reasonably and properly incurred due to the fraud, regardless of its foreseeability to the fraudulent party. Compare this to misrepresentation, which does not allow the innocent party to claim for damages. What they can do instead is claim for an indemnity, which will allow them to recover any expenses or losses incurred because of the contract. It is important to distinguish this from an award for damages, and to examine the distinction, we shall look at the case of Simthong Realty and Thekim Dar. In that case, the misled party claimed rescission of a contract for the purchase of land, the return of the deposit paid to the other party, and interest on the deposit paid. It was held that the misled party was only entitled to rescission and to the return of the deposit, as that would be sufficient to return them to their former position. Awarding the interest on the deposit would amount to an award for damages. Essentially, the misled party need only be compensated for expenses directly caused by entry into the contract. If the misled party opts to affirm the contract instead, they may claim for compensation to put them in the position they would have been in had the representation been true. This is the principle set out in Section 19, subsection 2 of the Contracts Act. An example of affirmation coupled with damages is the case of Dato' Suilai Singh and Kumpulan Sierama Sendirian Berhad. In that case, the defendant had misrepresented the extent of security measures provided in their housing project, compelling the plaintiff to purchase and move into the property. However, the plaintiff's house was robbed and he lost items valued at about 486,988 ringgit. The court held that the defendant was liable and awarded the plaintiffs special damages amounting to the total value lost plus interest at the rate of 8% per annum from the date of the suit to the date of the settlement. This would have been the position of the plaintiff if the security system had been set up as represented. In other words, if the representation had been truthful and the plaintiff had not been robbed.
So now we have come to the end of our video on misrepresentation. So now let's look at some similarities and differences under both English and Malaysian law for the topic of misrepresentation. So May, what do you have to say?
Common law fraudulent misrepresentation and fraud under Section 17 of the Contracts Act 1950 are similar. Additionally, common law negligence and innocent misrepresentation and misrepresentation under Section 18 of the Contracts Act 1950 are similar.
That's a good point. How about you, Iri?
We can see a big similarity under remedies, where in both jurisdictions, firstly, there's rescission of the contract itself. Secondly, there's indemnity pursuant to rescission. And thirdly, there's damages.
Now let's move on to some different points. Vinia, Savannah, do you have anything to add?
The elements for innocent misrepresentation in both Malaysian and English law is when the mind of the statement of the maker and the grounds is true, but the statement is still false. The concepts of innocent and negligent misrepresentation under English law correlate to the concept of misrepresentation of Malaysian law.
Negligent misrepresentation in both jurisdictions requires a special relationship or duty between the parties, a breach of that duty by making a false statement, reliance on the breach which misleads the innocent party into the contract to the advantage of the statement maker, and finally, the detriment of the innocent party.
Thank you very much. Now Prish, what are some of your thoughts?
Common law surrounding the principle of misrepresentation in both English and Malaysian law has struck a delicate balance between rescinding contracts that are between parties that are not at consensus ad idem and preventing the frivolous rescission of contracts. Therefore, the principle is indeed an important one within English contract law.